Welcome to Oberti Sullivan's video podcast. We are here to talk about the top 10 mistakes employers make and how to avoid them. This is part 5 in our series. Today we're going to go over mistakes 9 and 10. You can find a copy of our presentation on our website, www.osattorneys.com/presentations. And we thank you for joining us. Mark, I guess tip number 9 is when employers overlook the NLRA, or the National Labor Relations Act, they may be making a grave mistake. Why don't you explain?
Sure. The National Labor Relations Act, it's getting a little bit more publicity now because of some social media cases that have come up. But employers still need to be aware of it, and oftentimes they're not. And it typically comes up in the context of one or more employees articulate some concern about working conditions that affect employees at the job, whether it's sometimes it's a manager that they don't like the way the manager is treating the employees, or maybe some policy that they object to, and they voice their objection in a way that the company believes is inappropriate, maybe crosses the line into considered insubordination, and so they get terminated for violating company policy. And then the employee files a charge with the labor board, and come to find out, underneath the National Labor Relations Act, there's a clause, Section 7, that says employees have a protected right to engage in concerted activities regarding the terms and conditions of employment. And as you can see from the slides, I think maybe if we move on to the next slide, there's a couple of cases that we talk about where, for example, like I said, this Trumpler case, an employee did just that, and the National Labor Relations Board said, you know what? When you fired that employee for griping about what he considered to be a poor manager, that was a conduct that was protected under Section 7, and it was a violation of the law.
I think this is really shocking to a lot of employers who may not have any familiarity. They don't have a unionized workforce. They don't understand that the National Labor Relations Act, which has been around for nearly 80 years, somehow applies to them. But it does, and employers should think about that, because sometimes employees get together and they want to do things to, maybe not bargain collectively, but act in furtherance of their rights, or their rights to negotiate wages, or things that are protected by the act, that they'd fall right under it.
Yeah, a common one is this Main Street case, and there the company had an unwritten rule that said, hey, we keep all our pay information confidential, folks, and so don't talk about your pay. And that's a very common rule. And so employees started talking to each other, hey, you're getting paid more than me, we should do something about this. And the company found out about it and said, you're fired, you're violating our policy. Well, went up to the Sixth Circuit Court of Appeals, and they said, you know what, that's just a basically pretty simple case, just a plain violation. These employees were talking with one another about terms and conditions of their employment, and that's protected activity, and you can't fire them for it, even if you have a policy that prohibits it. The policy itself is a violation.
And of course, we've seen a lot of this recently with respect to Facebook. A lot of employees are friends with coworkers on Facebook, and I think in one particular case that got national attention, an unfair labor practices charge was, I think even brought against a company because one of the employees had complained about conditions at a particular workplace.
Yeah, in this Hispanics of Buffalo case, the employee, I think, had sent a Facebook message just griping about conditions at the workplace, and the company's attitude was, hey, if you don't like it here, get another job, you're fired. And the administrative law judge with the National Labor Relations Board said that's a violation. And what these cases oftentimes boil down to is, let's say that same employee went on Facebook and said, well, let's get together and burn down the plant. Well, in protest. Well, that clearly crosses the line, and it's not protected anymore, and it's unreasonable, and it disruptive to the company. But if that's the line that needs to be crossed, otherwise it's generally protected. And so good advice, and this is going to go with number 10, is before you fire somebody for something like that, even if you're upset about it, you might want to take a time out and talk to a labor and employment lawyer who really knows this area.
Yeah, and I think that segues really nicely into the top 10 mistake, or the 10th mistake of top 10 mistakes, which is frankly not really consulting lawyers who know labor and employment law before a termination occurs or a risky termination occurs. And it's just real simple, which is we represent a lot of employers, and we understand that there's a groupthink that goes on a lot of times, or frankly just tired of an employee, want to get rid of that employee for a number of reasons. And we get it and we understand, but you have to understand that sometimes might look strange to the outside world, and it would be good to get perspective, a legal perspective, on how that decision looks.
Yeah, I mean, it's hard for the jury to walk in the employer's moccasins, so to speak, and really understand the pain that some of these employees put on the company. And so it's good to get that outsider's perspective before you pull the trigger. Another thing is, sometimes you have some managers who cling to that at-will rule, and especially here in Texas, you'll hear people say, well, we could fire you for any reason or no reason at all. And while that may be technically true, well, we haven't found that that's really persuasive to juries. And so those are the sort of things when a company calls me up and says they want to do that, it's good to get ahead of that, because that's not something you want to really hang your hat on once you're in litigation.
I just think it's a bad idea for a bunch of people to get together and there not to be anyone just say at the meeting, well, hold on, let's look at the other perspective here for a second. Now, there may not really be another perspective in a lot of circumstances, and we understand it if someone engaged in something of violence or something that was just horrible. But it makes sense and to take a little bit of time and to think through your termination decisions. Even if you don't go to a lawyer, just simply going to HR. If you have an independent HR person who can look at terminations with an objective eye and isn't going to rubber stamp decisions, that's a good thing. And it can't be a bad thing. And juries will expect it. And if you do it the right way, then juries, I think, will appreciate it.
Yeah, 2 points there. One, not to toot our own horn, but we've got a termination checklist on our website, www.osattorneys.com, and if you follow that checklist, that'll go a long way to preventing litigation, or at least litigation you can't defend. And two, like Ed said, it's a real good point, is even if substantively you end up making a decision that maybe can be attacked, if the process that you followed shows good faith and a diligent effort to do the right thing, you'll be rewarded for that by a judge and a jury, at least in some respect.
Most of the wrongful termination lawsuits that you see emanate from a hasty decision that was made. The more documentation and the more deliberation that goes into a termination, typically the safer you are in avoiding a lawsuit, which may be sort of, in other words, you're being penny wise to actually engage in some productive analysis at the front end.
Yeah, and like we say, sometimes I think companies get confronted with some situation, they feel like they have to act immediately. And sometimes I think the way to deal with that is suspend the employee or put them on a leave of absence. Don't do anything then investigate, nail everything down 100%, get a written signed statement from the employee about their response to the allegations, which I always like to do, then make a decision. And the other thing is by getting HR and legal involved and kind of mapping out how you're going to do this, you avoid the problem that you saw in that slide in Weaver versus Amico, where the manager was just told, well, go talk to this employee and let him go. Well, the employee had a tape recorder on him, and he basically poached the manager into a conversation about age, and ultimately this manager ended up saying, yeah, it's your age that got you, it's just time for you to go because of your age, which ultimately led to a successful verdict that was upheld on appeal. And those are the sorts of things you can avoid when you have meaningful HR and legal input up front.
So, thank you very much. That concludes our top 10 employer mistakes and how to avoid them. We hope you've enjoyed this.